Hey guys, this is Nick Christophers from Mob Tales. Hope everything's going well. Uh, we have a interesting guest today. His name is Dave Grosky, if I'm pronouncing that correctly,
Yeah,
and a very interesting background and what he's been through. And we like to shed some light on it and get some people a little bit of information that I think they should know. Dave, thanks a lot for coming on the show. I appreciate it.
no, it's a pleasure being here, and thank you for having me.
Sure, sure. Um, Well, my first question would be, of course, I know before every things went, sideways. Um, you were an attorney, which you still are now, but you were an attorney way before things went sideways, so to speak. Um, how long were you practicing as an attorney before things got kind of shaky?
15 years. I was a member of the federal trial bar in the Seventh Circuit Court of Appeals for the Northern District of Illinois, beginning in 1987, and practiced law actively for 15 years. Actually, continued to practice law even after I took on the role as CEO and chairman of the board of a company called Afora. It was a startup biodiagnostic company that we moved actually from California, where it began, to the Chicago area in 1997. So in 1997, I actually took on that role. I was one of the early investors in that company. And then I was asked by the other larger investors to become its CEO and chairman in 1997. At that point, while I still maintained my license and still on occasion handle cases, because my background is as a corporate and bankruptcy litigator, so corporate commercial law litigation in both federal and state court in the state of Illinois during those 15 years. I continued to practice law, but only to a small degree at that point. I was essentially working for this company full time as its CEO.
Right. So, speaking of that company, um, if that was the company that you had unfortunately came into a problem with them, if I'm correct.
That's
Um,
correct.
and you and another gentleman, Rappin, I believe was his last name, um, ended up going away for a couple of years, for like I don't know, for X amount of years, in reference to a fraud scheme. Can you give us a little bit of detail on that?
So the company began as a development company, early stage biodiagnostic device development company, uh, initially with the charge of simply developing a singular test, a rapid HIV diagnostic test, whereby a drop of blood would determine whether an individual was HIV positive. There were other companies working on this at the time, some public, some private. Ultimately, we developed a test, as did the other companies. A couple of the other companies did receive FDA approval. We did not. It wasn't because our test was not efficacious and properly performing. It was a question ultimately of the data, maintenance of the data. It's a significant amount of data and testing that has to be done to be able to achieve this FDA approval, and there were problems with the data maintenance essentially. But the test was a world class test. It was written up in scientific journals for several years as being the equal of the other tests that ultimately received FDA approval. And though the company began with that singular focus, when I became involved, we actually expanded that by bringing in scientists from several of the leading biodiagnostic companies, including Bayer, Johnson and Johnson, and Abbott Labs. And we began to develop other tests, including tests for blood glucose, and at that time, a disease which was catching great coverage in the press and was of major concern to the National Institute of Health in the United States, called mad cow disease. Now, since then, it's really a non-issue at the moment. But at that time, it was a great concern, both in cattle and in deer and elk. The deer and elk, it's called scrapie. But anyway, it was mad cow disease. So we were working on multiple tests. I was the CEO of that company, became CEO and chairman of the board in 1997, and I remained its CEO and chairman of the board until 2007. The investigation into the company began as a Securities and Exchange Commission fraud investigation. The fraud not relating to theft at all, but relating to what we call technical violations of the federal securities laws, which are a number of different things in this particular case. Not going into what's called a quiet period for a lengthy period of time between offerings, selling the stock that we were selling to too many unaccredited investors, which means people who were not of a financial means to be suitable for the investment. Those were the primary ones, and then overpaying brokers for the money that they were bringing in from their investors. We were overpaying a fee that was not allowed by the SEC. Most cases in the United States, I would say to you, because I've studied it, 85 to 90% of SEC civil fraud cases remain civil fraud cases. They do not morph or elevate to a criminal indictment. Mine did.
Right. So what caused yours to reach that? From what I understand, it was because of the amount of money they claimed.
The amount of money, and they never tell you, but I think a lot of it is the majority of these investors were located in Illinois. Let me simply say there was a cadre of those investors that were very influential politically. I'll leave it at that.
Okay, I got you.
So they had influence with the United States attorney to elevate.
Right. And remember, so if I remember, in 2009, you put in, if I remember, if I'm using the right terms here, you contested those charges, and you went to, it was brought to court and everything.
Yes, I actually brought what's called a ineffective assistance of counsel post-conviction motion filing, which I ended up, we'll talk about this momentarily, but I ended up specializing on that, assisting other inmates in doing so. My case, frankly, was not a strong one for that. And I knew that going in, but I still nevertheless wanted to file.
Right. Well, that's a smart thing to do. You got to try, right? You got to make an effort.
Right.
So they based it. So what was their basis of not honoring that? What was the, from what I understand, from what I read about, they thought it wasn't substantial, it wasn't enough. You didn't have enough of a foot to stand on in reference to that case.
It's very difficult to attack a guilty plea on ineffective assistance grounds. The majority of cases that are won, which, by the way, I would say to your audience, is at best 5%, whether you go to trial or plea. In a plea setting, it's probably 1%. And that's because all criminal defendants in federal court attend what's called a plea colloquy hearing, at which judge asks you very detailed questions on the record under oath, that you were satisfied with your attorney, that you received proper representation, that you knowingly entered into this plea in every respect and are not being fooled in any respect, etc. So in the end, when you later attack the attorney, it's very challenging to do so after you made those statements in court under oath.
Well, but in that respect, so people can understand, I understand when you're taking that oath, but at that point you believe that, you know, this counsel will be to your favor. But if things go south and it wasn't, you know, he or she didn't do the proper, you know, do the proper thing for you, don't you have a foot to stand on and say, yeah, I was misrepresented?
You're 100% correct, but that rationale has been tried by thousands of federal defendants and never once worked. And that's because the system is what it is, which is, as I say, when I tell you 1% of guilty pleas result successfully in an outcome on these ineffective assistance of counsel motions, that's largely why, because you're precluded effectively from making that argument. You can't even make it. But it is actually logically valid, what you just said. In other words, you could believe at your plea colloquy hearing, and even at sentencing, that your attorney is doing a very fine job. Come to learn later the opposite. Because among other things, you're a deer in the headlights generally as a criminal federal defendant at that stage. You're not even necessarily being able to see much. Later, you review everything very carefully, and it may well be that you had a change of heart or a change of your viewpoint on it, not based on emotion, but based on the facts. And yet, courts, is a rule in the United States, the federal courts, and we're not talking about the state system here. This is just federal that I'm referring to, will
Mhm.
not even allow that argument.
So
In
that's,
other words, as we like to say, the fix is in.
yeah, yeah.
And it
Uh,
really is. I mean, it just is. And
well,
and we'll talk about this a little bit in a moment, but that really gets into the heart of my discussion of prosecutorial overreaching and misconduct overall. But that's one example of judicial overreaching and misconduct, in my view. The fact that that type of argument is not even permitted, what you just had mentioned, which is should be permitted because it's very logical.
well, the other thing is, it's funny you mentioned that because speaking of somebody we both know, we've heard about, obviously, during the Gotti trial, they disbarred Bruce Cutler from ever representing John, even though that was his preferred attorney, because of supposedly House counsel. And then he had to get the other attorney to represent him instead, who was his first pick. So basically, he was denied his given right to pick whatever counsel he wanted. So it's almost the same theory, no? Because you're being told, no, you got to go this way, you can't go that way. kind of.
Exactly. It's a very long-standing mechanical system that certainly works against the interests of the criminal defendant in the federal system, as a rule.
Interesting. Well, um, after you got out, you decided to do something similar that you were doing inside, trying to help other inmates with their issues, with their problems on the legal side because of your experience and your knowledge. Um, what motivated you to go to work on these kind of things?
Because I saw when I was in for 11 years that providing federal inmates with some level of hope in these filings, with a full disclosure at the outset that the hope is minimal and yet there is hope, and as you were saying earlier, you have time and you have all the reason to still want to fight. I think mentally for the inmate, it's very important not to give up and to keep fighting. And so I continued with that thought once I left prison. And, to this day, I'm helping many federal inmates around the country, mostly on a referral basis. But I also sit on the board of legal advisors of the Hinda Institute in Niles, Illinois. It's an organization that is dedicated to assisting families and their loved ones who are incarcerated. And, that work I do, pro bono. The niche, I guess you could say, that I have, if I would have to identify it, is the assistance of pro se litigants, self-represented litigants who cannot afford legal counsel, which is common, of course, once you're incarcerated. Those incarcerated and their families oftentimes cannot afford 5, 10, 15, $20,000. I charge, if I do charge, a fraction of that, 10%, let's say, at most,
Well,
for the same type of work, actually.
right. Well, since you've been on this journey, have you had any success stories that you can speak of?
I've had, during my time of incarceration and then thereafter, I've probably filed over 100 2255 ineffective assistance petitions, and I had 3 successes while I was in prison on that number, which is a little less maybe than the average national average of percentage victories, but almost all that I was dealing with were pleas. I didn't deal with many trials, it just so happened. I did have significant successes more recently with compassionate release and 2-point reduction motions, which are motions of more recent vintage with changes in the law after what you may be familiar with is called the First Step Act,
Yes.
which is new law that was enacted a few years ago. So I have many people I've assisted who have been placed on home confinement and are no longer in prison far earlier than they would otherwise be. Generally, the major reason is health related issues of themselves and or family members who have no other caretakers other than the individual inmate to care for them.
Well, since was your license as an attorney, did that change? Were you in fear of losing it because of
Well,
the time that you did
well,
it?
I lost my, part of at least in the state of Illinois, an automatic aspect of pleading guilty in a federal criminal case is the voluntary surrender of one's legal license. So I lost that in 2008. What I'm doing now is I'm not ever, of course, appearing in court, and I'm not even ever signing a pleading. I'm assisting these individuals with research, writing, and they're signing the papers in all instances, self-representing. But I'm basically their scribe and their researcher because they don't have that ability to do so.
Oh, okay. So you're like the rabbi,
In a sense.
in a sense. Oh, okay. Well,
Maybe more consigliere, wartime consigliere, possibly.
well,
Because we know it is war.
yes. Speaking of such, I'm sure you came across some wise guys inside, I'm sure. Um, while doing so and meeting some of these individuals, have they ever reached out to you for you to help them to represent them in something, some capacity?
Yes, but not so much in legal, more in the business side, business consultancy. One in particular who I became very dear friends with at FCI Milan, who I continue to be very dear friends with. Some legal advisory stuff, but mostly it's business consultancy on things he's been doing since he's been released. But no, I met many, and I have very fond memories. And as I was mentioning to you in preparation for this, you know, a lot of fond memories, a lot of I learned a lot. Let's just say that about life
So you did.
from these individuals.
Were majority of these gentlemen from the Chicago area or from
No, most were from Philly and New York, because I began at FCI Loretto in Pennsylvania, where I met many.
okay.
And then I ended up moving to Morgantown, but then I moved to FCI Milan and met several. Now the Milan last 6 years, these were mostly Midwest guys.
Oh, interesting.
Let's say Midwest wise guys. Let's say.
Okay. Gotcha.
Mostly Chicago, but I became very friendly. Now, some of those I did help with legal work actually, but at Loretto I didn't. In Loretto, I made some good relationships, and but again, my major relationships with one individual, but it was mostly business assistance as opposed to legal.
All right. So currently you are still, helping individuals with their case, with their, plea cases and stuff like that. If individuals want to reach out to you to speak to anybody who may be listening at the show and have somebody that's inside and they need some advice or some help, how would they find you?
Well, it's all the work I'm getting is essentially referral from people in prisons. But I had mentioned to you, you could feel free to give out my number and my email address. Normally, I'm working with families very closely, so but I also am on core links and communicating by phone with many of the inmates on the prison phone systems. But no, I'm very happy to speak to anyone who would need assistance. And I don't know, if they're inside, how are they going to learn about me other than maybe through their families? I don't know
Right.
directly anyway, other than and this is how mostly I receive my referrals from other inmates I've been working for. And then they say,
Right.
I'm working with this guy, David Grosky, you may want to give him a call.
Well,
That's how it's usually happening.
when somebody's inside, that's just some people may be listening or trying to understand. Um, there's a limit of how many times you can appeal a case, correct?
Very, very great limitation, actually. Yeah. And in fact, I speak to many inmates, unfortunately, who are precluded, as a practical matter, by the passage of time and the fact that they either didn't file in those limited fashions, or the time, or they did so unsuccessfully, and at this juncture they don't have any other way back in procedurally under a particular statute or rule allowing them back in on that particular issue. Now, the good news is, as I mentioned earlier, the expansion of the compassionate release and 2-point reduction laws recently, in effect, is giving some of those people who would otherwise historically be precluded from actually getting in now under the auspices of these expanded newer laws. So I'm having good success that way, but the courts are very loath on allowing, even on issues of you know credible concern, individuals who didn't pursue in a timely manner, because the idea is if you didn't pursue, then it must not have been that important to you. On the other hand, many inmates just aren't schooled on these rules of they weren't told by their attorney, they have 1 year to file this or that or the other. But again, and this is another problem with the system, ignorance of the law is no excuse in the eyes of the federal courts. You can't come in and say, I just didn't know I had a deadline. That never flies.
So if you exhaust your appeals, let's say you argue you did, and let's say you're doing a life bid, so you exhausted your appeals, what kind of outlet would they have at that point?
The only way out at that point is compassionate release based on medical issues. That's it. In that scenario, that's the only way.
Oh, okay.
Now, up until recently, you had to literally have a letter from a treating physician saying you have less than 1 year to live in all probability. But now it's expanded far more than that. Now the standard actually is, if one can make a credible showing through credible medical evidence by, again, physician evidence and letters, that the treatment they'd be receiving for chronic or potentially fatal conditions is not being treated nearly as competently within a prison setting as if this individual was on home confinement, that is ground for being placed on home confinement. That standard, which is far more relaxed than the historical one, is leading to successes for individuals because it's not terribly difficult as long as you can get, well, number one, as long as you have those type of serious medical conditions, but also getting the right evidence in place through your treating physicians.
So the compassionate release is only based on medical condition, not on anything else.
No, well, it's all, there's another element to it. But this is not easy at all. If you can establish that your sentence today would be lesser based on changes in the law than it was then, that is another ground that people are attacking.
Okay. How about if there's been a new discovery, new evidence?
It has to be established as newly discovered evidence that absolutely couldn't have been known then, and that's not easy. Sometimes an individual will say, I just didn't know, and then the court will say, but you should have known because it existed. You just happen not to know.
How would
Now, in a murder case, for instance, if there's an alibi witness, or hypothetically, you can prove it was another person who murdered beyond a reasonable doubt based on whatever evidentiary testimony you have or documentary testimony, that would suffice. But that's not common, as we know.
Right. Okay.
I mean, newly discovered evidence to establish actual innocence, not factual innocence, actual substantive innocence, is the strongest ground. But again, it doesn't come up too often. Many years later.
Okay. Would a civil case, a civil issue, like something civil, would that be workable, or that be can they use that as a stepping stone?
Such as what? Give me an example, if you
Like a
could.
civil case where there were, well, I'm gonna try to use the one of the guy I know, friend of mine. I talked to you about once.
Okay.
Now his case is like a Whitey Bulger case, if you know what Whitey Bulger is,
Yeah.
where he was wrongly convicted and doing time for somebody else
Right.
who's being protected by the FBI.
Right.
So, and there is evidence out there that, I mean, even I investigated and I found information So there is documents or information out there that proves that my my friend is definitely not the one that was responsible. And he's been in prison for 24 years for something he didn't do.
Oh yeah, evidence can come from any angle or any area. It can come from a civil case. It can come from a situation that has no involvement with any litigation. So yes, in a civil case, if you can establish criminal case or criminal conviction innocence, yes, absolutely.
Okay, interesting. The thing is, do you know about the organization called Wrongly Convicted, I think it's called?
I'm familiar, yeah.
Yeah. Well, the one you spoke about earlier, that's based in Illinois, that
Yeah.
you're a part of, um, are they similar in what they do?
Well, the organization I'm involved with is not an innocence project per se. It assists anyone who's in prison for any reason, with both mental health support, family support, to a degree, financial support. So it's more broad based. It's not just, to establish innocence. It's to support even if one isn't innocent.
Ah, okay. All
You
right,
know?
I got you. That
Yeah,
makes a difference. That's definitely a difference.
yeah.
Uh, so they're more of a they assist the inmate in some capacity
They
with,
provide support
right,
in a number of different
in his
ways.
current situation. Okay, I got you. And what's the name of that organization again?
The Hinda Institute, HINDA,
And then, okay, and that's based in Illinois.
in Niles, Illinois.
Now, Illinois. Okay, excellent. Well, Dave, listen, I really appreciate you coming on and educating us in a huge way. Um, I would definitely maybe later on uh, have you on the show again, depending on what subject we can cover. Because we're getting to the end of the show at the moment. But if, like I said again, people to reach out to you, um, is there any kind of social media place they can find you and maybe touch base with
Well,
you?
just LinkedIn, really LinkedIn.
LinkedIn. Okay. All right. Awesome. Well, Dave, listen, thank you very much for coming on the show. I really appreciate it. Oh, one last thing.
Yeah.
With your interesting background and what you've been through, have you ever thought of putting that into a book?
I will be authoring a book when life slows down a little bit more for me. I come from a family of writers. The book will be centered or focused upon uh, educating the public on governmental overreach in the judicial system, but also on lessons learned and, kind of a mix of self-help for people and also, educating on these different issues. So a combination of things. But yes, there will be a book.
Yeah, that definitely sounds great. Awesome. Again, thank you, Dave, once more. And we'll definitely keep in touch, that's for sure.
I certainly hope so. And thank you. And you have a great day too.
Good, Dave. Thank you.